Thank you, Christina. Thank you, everybody at the Des Moines Partnership, and thanks for joining us this morning so we can talk to you about the top 5 documents in every employee personnel file. And my name is Brent Hinders here with Hugh Cain and Eric Updegraff. We're the primary hive mind of the employment law section here at Hopkins and Huebner in our Des Moines office. And that's where we're filming today in lovely Des Moines, Iowa. It looks like blue skies out today, hopefully not as hot as it's been. We're talking about the top 5 documents in your employee file. However, that's deceptive. We're going to talk about a lot more than that, but we want you to at least have that the knowledge of the top 5 documents to keep in the file, as well as things to keep out, and that's what we're talking about today. Go to the next slide. So these are the things that when you open up a employment file should be or could be in that employment file. So we look at date of employment, application, resume, I-9 form, the benefit information, handbook acknowledgement, any discipline, progress within the company, so promotions and increases in pay, reviews, performance appraisals, attendance, the Fair Labor Standards Act required information, so your payment and your tax information, any training records, or at the end of the employment resignation and termination documents. Obviously, not every employee is going to have discipline. Not every employee is going to have all the different documents, but these are documents that should be in the employment file. Also, note that there are several documents such as medical information and correspondence with legal counsel that should not be, because they're not included on this list. So we'll talk a little bit more about that, but we're going to start off with the number one thing to begin your journey in any job is the application. Hugh will talk to us about that a little bit.
So your job application, when I first started practicing, of course, was in paper. Nowadays, I don't think I see any job applications that are in paper, but I suspect there are. But whether you're in paper or electronic, your job application should always have at least 3 important statements. And they can be at the very end where somebody is signing. And the first one is you have that person verify that the information is true and correct, and that any misrepresentation or omission can lead to a dismissal. That's important because you want to make sure that what they've told you is true. And by the way, if 2 years from now you find out that there was resume fraud, or if there was something else that was important that wasn't included, it provides you a legitimate basis to end the employment, and it provides a defense that to sort of a wrongful termination or discrimination clause. The next statement that you should always have is that the applicant has authorized you as the employer to verify all the information on an application, so that they are authorizing you to, call the people that formerly worked for, or they formerly worked for, or are listed as a reference. Now, you will likely find out that most people will not want to talk to you unless you provide them with a release. So depending upon how broad that authorization is, you may not get the information that you want, or the authorization may have to include language like, I hereby release any former employer from any and all liability for answering questions. I mean, there's all sorts of permutations that could happen with that authorization, but at least it should have some authorization that the applicant is allowing you to contact people. The final thing that every job application should say at the very bottom, just before it's signed by the applicant, is to confirm that all employment is subject to the, or everybody's an employee at will. Now, an employee at will isn't worth as much as it used to be. As you know, an employment at will basically says that you can be fired for any reason as long as it's not illegal, and at any time they can be let go. Well, as you all know, if you've been in employment or HR or an employer for a number of years, there are as many holes in the at-will doctrine that you could drive Mack trucks through. But it's still important to have that verification and confirmation that anybody that is going to be an app or an employee is an employee at will. So as a sort of an adjunct to the job application, you should also have, we want to go forward, Eric.
There we go. It was an interview question.
Yeah, we want to go to job. We want to go to, yeah. Let's see. So let's talk about questions you shouldn't ask. So things that you shouldn't ask about in an interview. Those first six, those are right out of the Title VII and the discrimination law. So you don't ask about race, religion, sex, age, disability, or national origin. In addition to that, there are the two new areas that you never ask about, which is sexual orientation and gender identity. Just don't go there. Those are questions that you should never, ever ask. Now, some of the other things are sort of permutations or they're sequelae of those. So for instance, you never ask about a maiden name. And the reason is because if you're asking about a maiden name, the law is going to assume that you are only asking that question to women. And the reason that you're asking is to try to find out if they're married. And if they're married, the law assumes you're trying to pay them less because they're a female. So don't ask about maiden names. Same thing with family and marital status. If you ask those questions, the law is going to presume that you want to discriminate against women because they have someone who is also supporting that household. So you can pay them less. Don't ask those questions. Pregnancy or intent to have children. Again, those questions are only going to be asked normally to women. So don't ask it because the law will assume that you want to discriminate against those people and not hire them because they have childcare responsibilities. Next one is don't ask about height and weight. Back in the 1970s, the US Supreme Court held that asking about height and weight is basically a way to discriminate against women because women are smaller and their height is less and their weight is less. And that if you're asking about those things, that's a surrogate way to discriminate against women. Don't do it. Don't ask about a spouse's name or occupation. And again, it goes back to the assumption that if you were asking those questions, it's because you want to find out if the female applicant is married and what her husband does so that you can pay her less because he's working somewhere else. Don't ask about membership in organizations. And the reason you don't do that is because you are likely to get information regarding religion so that you'll find out that they are a member of a certain parish or that they are a Knight of Columbus or something that will be tell you what their religion is and that you then could discriminate against them because of that. Don't ask. Don't ask if somebody's a citizen. It is folks who are authorized to work in the United States are protected. You can ask, are they authorized to work in the United States? But you can't ask about citizenship. For birthplace, generally don't ask about birthplace because that gets you national origin information. So if somebody was born in Bosnia, the law is going to assume that you're asking about that because you want to discriminate against Bosnians. Don't do it. Arrest records. This is the big deal in recent years. As you probably already know, folks who are in racial minorities are arrested far more likely than white Americans. Don't ask about arrests because it would allow you to discriminate against racial minorities. And the other thing you should keep in mind is that anybody can be arrested. Arrest can be simply, I'm in the wrong place at the wrong time. It's convictions that are the important thing that you could ask about. Have you been convicted of a crime? but you don't ask about arrest records. Similar thing with credit history. Women and racial minorities have statistically a lesser credit history than white men. So do not ask about credit history in an interview, because the law will assume you want to discriminate against racial minorities and women. Don't ask about dates of education, because if you have dates of education, you can normally easily figure out how old somebody is. And as soon as you know how old somebody is, then you're going to have information that would allow you to discriminate on the basis of age. So don't ask about the date somebody graduated from high school or the date that somebody got their college degree. Don't ask about workers' compensation questions in an interview. And the reason is because you're not entitled to know anything about workers' compensation in an interview. Once you make a conditional job offer, you can ask about that question. With COVID, the new question that sometimes is asked is, well, can I ask somebody whether they're vaccinated? No, don't do that in an interview, because vaccination is likely a medical record, and you're not entitled to know about medical records until you make a conditional job offer. And you don't do that in a typical interview. So then what are some of the questions that you can ask? You can always ask somebody, these are the hours that my business is open, and can you work those regular hours? That is sometimes you may get information regarding childcare, but again, you have asked the question correctly. You can ask, are you intending on staying in the area? You can ask somebody if they can relocate. You can ask them if they can travel as necessary. You can ask them if they can work overtime, either at nights or weekends as necessary. All of those questions are permissible, even though they may get you information regarding childcare, marital status, and things like that. But you can ask those You can ask those and not have problems. So then that takes us over to maybe a sequelae of interview questions, and that is job descriptions. And Eric, if you want to switch over for me, thank you. One of the things that you should couple your application with is a job description. Job descriptions are really very valuable tools, because you can use that tool then to go through somebody's qualifications for work, and the person will know what the job entails from the very beginning if you can hand him or her a copy of a job description. So you've got a knowledgeable person because they know what the job is, and you have a tool that you can use then to ask questions regarding. So those are really important things to couple with your job description. And then if we go to the next one, so how do you do a job description? Generally, you want to have your job description before somebody starts a job. Generally, it is a good thing if there is a job description for every job in your organization. And depending on how big you are, that certainly could be a full-time job just creating job descriptions. But at the same token, if you know what it is that you want people to do, you are better off having that job description. Now, that doesn't mean it can't change over time and that somebody's job can't evolve. But if it does, then it might be appropriate to set out the new job description and do it in a fashion where you have changed it and you have the person sign off on that document, and it goes into the personnel file. So those are things that you might want to consider when it comes to a job description. The other reason that you have job descriptions is because of the ADA. The ADA was passed back in the 1990s. And what the ADA, which is the Americans with Disabilities Act, says is that you can't discriminate against a qualified individual, and that you are obligated to reasonably accommodate that person unless it's an undue hardship. Somebody who's disabled has to be able to perform the essential functions of the job. And essential functions is an important term. An essential function is what somebody actually does, which is if you were to take away that function, it would fundamentally alter the job. And what the ADA says is that if you have a written job description, it is prima facie evidence of the essential functions. Now, why is that important? Because most times, if you create evidence that you can use in court, you go to jail. But under the ADA, if you create that job description, the law encourages you to do it. So you aren't going to go to jail because you created evidence. So have a good job description that talks about the essential functions. So if we go to the next slide, how do you do essential functions for folks? You have to determine what it is that this person or this position actually does. And then you list it on the job description as the essential functions are X, Y, and Z. You have to be concerned about what is it that somebody really does. If I have come up with more than 5, 7, or 8 essential functions for a job, I need to start rethinking, have I done this right? Because the essential functions are the actual important things that if you take away that function, you fundamentally alter the job. Now, before the ADA went into effect back in the 1990s, I used to see job descriptions for a floor nurse in a hospital. They would list 3 pages, single space of the duties for a floor nurse. Under the ADA, that's madness. You don't have 3 pages worth of essential functions. No human being does 3 pages of essential functions. A job normally is going to have that somewhere, that sweet spot between 5, maybe as high as 10. But once you start getting into double digits of essential functions, you are probably misanalyzing the job. Now, why that's important is because once you get into a lawsuit for disability discrimination, it is the essential, if you can show that they can't do the essential function, then they're not qualified. But if you've listed things like, for a administrative assistant, that they bring coffee to their bosses, or the functional equivalent, that's not an essential function. That's servitude, and that's not something you should be putting in a job description, because those are things that you will be shot down on by the courts if you try to claim something like that as an essential function. You also need to make sure that you have regularly audited the job to make sure that you really do have the essential functions. Because if something has, a position has evolved over time, if the job functions have changed, you need to change your job description to make sure that you've done that. So that's what I tell you about a job description. And that takes us over to Brent, who's going to visit with you about I-9.
So just to start this off, I know how important to everyone Form I-9s are and how important Form I-9s are to the US government. So I had a very important moment in my life as a parent and an employment law attorney. My oldest daughter, Lorelei, this year got a job, and she filled out her first ever Form I-9, folks. It is virtually the employment lawyer quinceañera for my daughter. I want to tell you, these are the most important documents just financially that everyone messes up on a regular basis. So please pay attention so you don't get the fines that are the easiest fines to figure out for the federal government. So here we have Form I-9. This is, let's see, we've got on the left, we'll have the first page. So the first page of the Form I-9 is what's filled out day one by the employee. Yeah, this is, let's see, no, this is the employer side. So employer, when you walk in, say, welcome to your new job, employer, fill this out day one. The other side is filled out with the employer verifying the information. So these are the different documents. So if you have a passport, that covers both your citizenship and your ability to work in the United States of America. The other documents that are the most common are driver's licenses and social security cards. However, what I want to tell you, and this is very important, you should not have a policy that says you can only bring in driver's licenses, social security cards, or passports. That because there are lots of people that can work in the United States and or are citizens that don't have those documents, aren't required to have those documents. But make sure that the documents that you have for Part 2 are verified. And the employee needs to bring in those documents on day 3, not day 4, day 3 of employment. If they don't have that, and all of these have timestamps on them where you have to verify this is the date I did this, is the date I did that. If they don't come in with day 3 of working with this, they don't get to come back on day 4 unless they have those documents to verify. Why is this so important? Because of the potential for fines from the US government if they come in and audit your Form I-9. So again, back to what I was talking about, who needs to complete a Form I-9? Everybody needs to complete a Form I-9 unless you were hired by the business before November 6, 1986. There are independent contractors, don't need to do the Form I-9. If someone works for you less than 3 days, they don't need to do the Form I-9. And also casual domestic service employees working in a private household when work is sporadic, regular, or intermittent. That's my daughter's other job of being a babysitter. She doesn't have to fill out a Form I-9 for that job. For the other job, she does have to fill out a Form I-9, which is, again, why I'm so proud of her. So, list of the acceptable documents. This comes with your Form I-9. So after you fill out the first part of the form, you should hand this list of acceptable documents to the employee and say, you need to bring this back next time. And if not next time, the time after that. And if you don't make it by your second chance or your third chance, you don't get to come back to work anymore. So we're not going to go into all of these documents, but these are the only documents that are established by the federal government that are fine. Your bus pass is not fine. An ID from a consulate is not fine. Your AARP card, not fine. Those are ones that, and I say these not because it's just funny, but because these are documents that we have seen copied into people's employment file that the federal government then laughed at them first, and then second, fined them $1,000 for not having appropriate documents. So know this list, look at this list, and if you don't know this list, or you look at something that says Native American tribal document, what the heck is that? There is a great resource online that you can look at that shows you in color what all these documents look like. The other part I would say is when you get these documents, remember to copy them. Now, some people will tell you don't copy them because if somebody falsified it, then you could get in trouble. I'm telling you, copy them because I want to be able to show the federal government, look, this looked like the document that it's supposed to look like. This looks valid. If it's something that's filled out in crayon or has, a picture that's a meme, and you accepted that, and the government finds out that you accepted that, and you don't have a copy, you're in trouble. So take a copy of those documents front and back, keep those in your file, and do it for everyone. Because if you just do it for a few people and not others, again, that could be discriminatory motive. Yeah, so here's our list of acceptable documents. One document from list A, or one document from list A, one document from list B, and one document from list C if you don't have it. Again, list A is usually the passport. B and C are usually the driver's license and social security card. Again, that's not required, but those are generally what we see. Section 1 is the employee information. This part has to be completed by the employee on the first day of employment. You have to, as an employer, you have to verify that the section is complete. And again, if you don't fill this stuff in, you have to fill this stuff in. It used to be that if you just had blank spots, they wouldn't count it against you on, say, email address, telephone number. Now they require you to put not available or not applicable in there. Let's see. We've got a question. Great. When hiring an employee whose onboarding is done 100% remote as they live in another state, what is the best practice for obtaining the required I-9 documents? So I've seen that done a lot of different ways. A lot of times you're just going to have somebody copy and send that information to you in a PDF file. Just so long as you have those documents, you're able to verify that those documents are accurate. I know there are people that have said, okay, I get the PDF document, but I also want to do a Zoom call with you where you hold up the document and I record that and keep that. So it's whatever comfort level you have with verifying those documents. Again, I would always recommend more, but we're attorneys. We always recommend more, so you have more defense if the government ever comes knocking and say this isn't the person, this isn't accurate. The other part is that for Form I-9 documents, these are all you can get virtual versions of these, so they're not just filled out by hand. The nice part about the online versions are they go back and they tell you, just like if you're putting in your credit card information, trying to buy something off Amazon, if you leave out information, it goes red and says you need to put this part in. So they tell you in that no, you need to put this section in or put not applicable in here or not available. Now, and if it's something that's not available, that absolutely has to be in there. They don't let you use that as an excuse. Again, the thing that's changed over time is if you don't have information, it used to be it didn't go against you if you just forgot to put in information or didn't put anything into a blank. Now the government takes that as evidence that you didn't appropriately fill out the form, and that can increase the fine that you have against you for the I-9s and how they're filled out. So I hope that answered that question. Section 1, employee attestation. You have to click one of the boxes here, select one of the 4 categories, and then they have to sign and date section 1. That can also be a virtual signature. And again, this is all done first business day of employment. This is something that should be filled out just the same as you're filling out any benefit information or any other tax information. This should be in the pile, and you should go over it with a fine-tooth comb, because remember, it isn't the employee that pays the fine if they get it wrong. It's the employer that always pays the fine. Prepare a translator if they need help with the information. You have someone that has disability, you have someone that needs a translator. This is where the translator fills that out. Here we have the second section, and let's go to the next one. This is the employer document review. We've already sort of talked about this. It's where you get either the column A or B and C. You have to examine the original documents, exceptions, certified copies of birth certificate. We've never heard anything about certified copies of a birth certificate, so I'm not going to go into any more of that information. I think that's been covered enough in modern society. The documents cannot be expired, so they can't give you a bad driver's license, or they can't give you an expired passport. Those don't work. They have to go re-up those documents. You don't need to be a document expert, but you should look at what I'm indicating down there at the USCIS, the I-9 handbook, to make sure the documents are genuine. Again, to the earlier question of how do you do it out of state, it's whatever your comfort level is there. And the government will take a look at that and understand that sort of information. Let's see. Oh yeah, receipt rule. Again, this is more a narrower situation where you don't have the document, but you can say, oh, I'm going to get this document, and then you have to check back up on the document. So if they've lost their driver's license or they lost something like that, or it's damaged, there's a little exception there, but normally don't see this one too often. If something like that comes up, you need to have a tickler at some point to remind you before that 90 days expires to get the correct documents. So you don't have to, for a work visa or a refugee admission stamp, if those need to be replaced, you don't have to get additional replacements or the receipts. Copies of documents, we talked about this. If you make a copy of anybody's documents, you have to make copies of everyone's documents. Be my recommendation to make copies of everyone's documents. Re-verification. So normally this is for an individual, say they're on a work visa, but you need to re-verify that the work visa continues to be up to date. If you have someone on a work visa, remember to, again, put some sort of reminder or tickler in your system to re-verify that before that date comes up. You don't need to re-verify the passport card, or a permanent resident card, any of the list B documents. So if somebody's driver's license expires, you don't have to re-verify that. But again, you have to re-verify, and usually it's the visa, the work visa is the one that becomes the biggest issue, and that we've seen the most issues with the federal government, that people just forget to re-verify, and you may have individuals that have gone past their work visa date that continue to work for you, so you get in trouble with a variety of U.S. agencies for having that situation. If you make a mistake, again, there's two ways. You can line out the incorrect information, put the correct information in, initial it next to that, or you can prepare a new Form I-9 and keep the old Form I-9. The reason why this is good is because if you walk out here today and go, oh my gosh, all I've accepted from people for the last 3 years are bus passes and their student IDs. I need to actually get real documents from them, or I'm going to lose my entire business. Keep the old part, but fill out a new Form I-9 with the original documents, and then put a little note on there that said, I didn't know until August, what is it today? 25th, 26th?
My bad.
Yeah.
Yeah. Federal government, my bad.
That's right. And so you have a note in there. The federal government will at least weigh the fact that you corrected it. Now, when the federal government comes knocking on your door and asks for the Form I-9s, and all you have is box tops from a variety of cereal boxes as verification of anything, you can't then go back and correct. It's too late at that point. So always audit your I-9s. Make sure that those I-9s are correct. Don't just have one person look at them, have at least two people look at them to make sure that they're accurate.
Yeah, so a few years ago, we had a long-time HR person left and somebody new comes in. And it turns out that the old HR person had not signed as the employer any of the I-9s going back decades. What we did is we had somebody now sign, but they dated their signature. So for instance, even though the I-9 itself was dated in the 1990s, the employer's signature is dated in the end of the 2020s or the 2020 teens, but they had a date. And that was the critical thing, is if the government comes in and there's been a change to the form or the ink is different, they'll want to know why. And having the date that you did something is a good way to protect yourself.
Missing Form I-9s, don't backdate. That's the big advice I'd have you there. Always be truthful with government documents. I can't stress that enough. Let's go to the next one. Storage of Form I-9s. There are lots of different thoughts on this, and it's whatever you're comfortable with. We have employers who keep the Form I-9s with the employee files. We have people that keep Form I-9s in a separate file. We have people that keep Form I-9s with the a copy in the employee file, the original in a separate one, and then they download it and keep it on the computer. The important part is so however you want to do it and whatever your comfort level is, do that. Make sure you don't lose the Form I-9s, number one, and number two is that keep them 3 years from the end of anyone's employment so the government can look back. And here, 1 year after the date employment terminates, 3 years after the hire. So keep those Form I-9s close. Penalties for violations, we've already talked about this. Most of it is the civil penalties. That's mostly what we get into. Fortunately, we haven't had the criminal penalties. The civil penalties, normally if you have a certain percentage of the forms that are, if I-9 is electronic, do we need to keep a copy in the file? No, not necessarily. Again, it's whatever your comfort level is. If you want to keep those in a password protected file on your server somewhere to make sure that you don't lose those, that's fine too. You just need to be able to divulge those to the federal government within 48 hours of them asking for it. So whatever your comfort level is there. But a lot of people keep them in the file just as a hard copy, just to make sure that everything is there, because they have a checkoff list, just like what we're talking about today. So thanks for that question. Again, you will get a higher fine based off of the number of I-9s that have problems, and problems are not filling things out, not putting on dates, not having correct documents. But the biggest one that we see is you just forget to fill out a section, or you don't put an answer into something that is ticked against you by the federal government. So fill out that form entirely. Don't see many criminal penalties, but if you do engage in a pattern or practice of hiring, recruiting, or referring for a fee unauthorized aliens, you need to talk to both an employment lawyer and a criminal lawyer, which you're lucky on both. So give me a call. But otherwise, I don't see a big problem with those.
Do you want to talk about you're still responsible even if your supervisor does it?
Oh, yes, correct. Yes, remember, the employer is always responsible. Doesn't matter if the employee screws up, doesn't matter, just as Hugh gave us the example of the HR manager not doing things correctly for 10 years. It is the employer that pays. It is the employer that could be liable criminally. So it is important, again, to have more than one person audit your Form I-9s and make sure those are correct, because it is your money that's lost.
All right, the next thing we're going to talk about is receipt and acknowledgement. So one of the big things, or one of the most important things about your employee personnel file is that it makes sure that you have shown that the employee has been told things, that the employee understands what the rules are, and that's what receipts and acknowledgements are about. You want to make sure that, for instance, if you have spent money on a handbook, or if you put one together yourself, you want to make sure that the employee has acknowledged that they've received it. Otherwise, you will get into a debate with them at a litigation, either in unemployment or in an employment discrimination lawsuit, or a wages claim, that, hey, I never saw this handbook. It was never available. No one could ever find it. Oh, it doesn't exist. No, you have to have them sign an authorization. In particular, it is very important to show that you have an anti-harassment policy. In employment discrimination lawsuits, specifically harassment lawsuits, there's a series of law that's called the Verger-Eller defense. And it's based on 2 United States Supreme Court cases that essentially say, if you're an employer and you have a policy, an anti-harassment policy that allows an employee to report that harassment to you, and you don't otherwise know about the harassment, you as the employer cannot be held liable as long as you had a policy, they were aware of it, and the employee didn't take advantage of it. It's essentially creates an incentive for you to protect yourself through these anti-harassment policies. Having the employee acknowledge that they've read the anti-harassment policy is extremely important for that Farragher defense. Because if you have an anti-harassment policy and you put it in a safe, throw it in the bottom of the ocean, it's not going to do anybody any good. So we have here, because we're lawyers and we are thorough, we have an example acknowledgement, and this is on our presentation. You can check out later. I promise I won't read it to you. I promise that I believe that all of your ability to read it on your own. And this is what I was talking about with Farragher. In particular, if you have exercised reasonable care to prevent and correct any harassment that you're made aware of, you get to take advantage of the Farragher. And that's the important second part of it, is that you have someone acknowledge that they've received it and they know where they can make complaints about harassment. And then either they don't make a complaint and you can avoid liability or some liability in those circumstances, or in the alternative, they make a complaint and you have an opportunity to manage your risks before it spirals into litigation. You have the opportunity to take prompt remedial action that can prevent harassment in the future. You can make those decisions. You can conduct an investigation. All of those things is what you get out of the Farragher defense, and having a receipt and acknowledgement in your employee handbook that makes it into the personnel file. It's very important. Lots of people have people sign the employee handbook and then it disappears. And then, as Hugh talked about earlier with the job application, you want to make sure to tell the employee as many times as possible that they are in fact an employee at will. It should be in your handbook, should be a disclaimer in your handbook, both at the beginning, at the end, sometimes in the middle. If you want to stamp it all over the place so that the employee does not come to the conclusion that the employee handbook is a contract that they can enforce against you. And if you could put that in the specific acknowledgement of the handbook, that's great. That would be part of the example we have. All right, and then we wanted to talk to you, just kind of all of us generally here, about the concept of ongoing documentation. I'll start here on this first one because it's kind of related to what I was talking about. In this context, what should make it into your employee file for purposes of defending yourself in litigation, whether it be unemployment case, whether it be a discrimination lawsuit, whether it be even a comp claim, is you want to make sure that you have all of your ongoing relationship documents in that file put together so you can provide it for your attorney and it doesn't get lost. That means things like performance reviews. You should be doing those. Discipline, leave tracking, FMLA leave, sick leave, pay for sick leave, all important. Payroll information needs to be in there. The discipline and the documentation about performance and discipline is the number one way that we can help defend you when you terminate an employee and they say that isn't right. I couldn't have been fired for X, Y, and Z. It's actually because of my race, my religion, my sexual orientation, any of those things we talked about earlier. If you have that in the employee file and it's contemporaneously documented, and that's what's really important, it's a big deal in the defense. In the legal world, there is a magic to things being in writing. And if you will take advantage of that magic and put together contemporaneous documents and keep them together in an employee file, that's great. If you create that stuff and leave it around willy-nilly, the problem we've got is you may lose it, or we may produce your employee file and that discipline's not in there. And then we have to later produce and say, oh, well, we also found this document that talks about how Steve isn't a good employee. Well, guess what? Everybody thinks you made it up, right? If it didn't make it into the employee file, then people are going to say, well, why was this just hanging around somewhere else?
So that takes us over to another reason why you need to document your performance and discipline is because there's yet another U.S. Supreme Court case that tells you how you process a discrimination case. It's called McDonnell Douglas, and it's from the 1970s, and it's still the law of the land. And what McDonnell Douglas says is the way that you process a discrimination claim at trial or in summary judgment is the plaintiff has to show a prima facie case of discrimination. Then the employer has to show a legitimate, non-discriminatory reason for the action. And finally, the employee has to show that is pretextual. So if you've got discipline and performance that shows that the employee is a screw up and has been doing all sorts of bad things, that falls right into your McDonnell Douglas #2 step, which is the employer has to show a legitimate, non-discriminatory reason for the termination or for whatever the adverse action is.
Sure, we got a question here. I'll answer it. The question is, do you recommend including a non-compete clause? Is this clause enforceable in Iowa? We don't always recommend a non-compete clause. A non-compete clause is maybe necessary based on what you do with your business. Non-compete clauses are enforceable in the state of Iowa, but they are only enforceable in the state of Iowa to the extent that they are reasonable in terms of their time, manner, and restrictions. You cannot, in particular, you can have a non-compete clause if your employee has important skills or information that they've gained through you that it would hurt you if they went to a competitor. I would say, for instance, you cannot have a non-compete clause for the cashier at the Casey's General Store because while you do learn important skills there, and you do important things at Casey's, you can't say, oh, you can't work at another gas station for the next 2 years. It's not reasonable. So when you have a non-compete clause, you need to try and be careful and tailor it to what you're doing in terms of your business and tailor it in terms of geographic scope and chronological time so it's reasonable. You cannot have a non-compete clause that says forever and ever you can't work in this industry again, because people need to be able to work and earn a living. And so courts will enforce those, but they will often enforce them in a limited fashion.
And the other thing you have to keep in mind is that, remember, the Biden administration is looking into whether those are enforceable under federal law. So you need to be thinking about what happens if the feds come after you. The other thing you need to keep in mind is don't put that in a handbook, because remember, the handbook says this is not a contract. So if you've got a non-compete, it's got to be in a standalone signed document.
The other part to that too is the state government just considered this year whether or not they wanted to limit non-competes in the state of Iowa and limit those to anybody that would make $55,000 or over that amount. That law didn't pass, but it's at least something that the Iowa legislature is considering limiting non-competes.
Right, and it's very simply because they understand that there are non-competes that don't make sense. I had somebody bring in a non-compete. They hung gutters, and somebody said you can't hang gutters in the state of Iowa for the next 5 years because you installed gutters for me. And no offense to people who install gutters, it's just not something that's really appropriate to have a 5-year non-compete for. It isn't. He couldn't even couldn't touch a gutter. And it's like, come on, guys, that's a lot. So the next thing we wanted to talk about is leave tracking. Some of you may be subject to the FMLA, some of you may not. One of the things that we recommend is that as part of your employment file, or you may have one large consolidated file, you need to track everybody's leave. And you need to track it so that you make sure that you don't give people more FMLA leave than they're entitled to. You don't give them too little FMLA leave so that people know what they're doing. You need to have in documentation for your FMLA stuff, your certifications for their FMLA leave. You ask them for a certification, say, hey, I have a serious health condition, or a member of my family does, and it's necessary for me to take care of them. That needs to make it into your file, or it needs to be kept, in a certifications concept. You can have the certification, but you want to keep your medical records separate. And that's kind of we have all of these talking here. Christina's letting us know that we have 5 minutes left. You want to make sure that you have your, as part of your leave documentation, you want to make sure that you're keeping track of sick leave. When an employee leaves, you may be responsible under 91A for paying them unused sick leave. If you forgot to track it, then you're going to have some problems with them claiming that they are owed it. You can have a policy that says that essentially you forfeited at the end. But you need to have that in writing in your handbook.
if we've only got 5 minutes left, why don't we switch over to medical records for a minute?
Sure.
Because
Here, we have
go
just related to what you're talking about. We have another question is, can FMLA be used for mental health? Seeing more employees struggling with mental health since COVID. Yes, absolutely. It can be. It has to, it's subject to the same certification requirements, but yes, absolutely. Mental health can be an FMLA condition.
And mental health of the individual or someone that would be a dependent as well.
And if you're covered by FMLA, make sure you download the forms from the US Department of Labor website, which is actually a very good website. And there you will find the forms that you need for FMLA. For medical records, the important thing, there are a number of important things, but one of the most important is medical records have to be treated confidentially. They have to be separately filed. Do not include your medical records in your personnel file. By the way, a vaccination record is a medical record, so don't put that in your personnel file. Your medical records have to be in a position that only those who have a need to know can access them. So they need to be either password protected, or if they're if they're actual paper records, they need to be locked. So only supervisors who need to know, the HR people who need to know, only those people should have access to those medical records.
These are the HIPAA. We want to bring up HIPAA here, not because it protects your right to not be vaccinated, but because as an employer, if you're going to ask for medical records, then you're going to need a HIPAA authorization to get them from the healthcare providers that the HIPAA law applies to. So that's one of the things that Hugh talked about earlier. It's having an authorization as part of your employment process, or have an authorization for your employee when you're going to get records from Dr. So-and-so, have them sign one that says, yes, Dr. So-and-so, you can give it to my employer. Generally, employers are not covered entities under HIPAA. So we get this question occasionally and a lot more recently. But you do have to be aware of it as an employer, because if you're going to ask for medical records, you're going to have to deal with it. Just want to mention, if you have a workers' compensation claim, the Iowa workers' compensation law says essentially you waive your, the employee waives their confidentiality requirements when they make a work comp claim.
Why don't we switch over, if we've got a couple minutes, to the OSHA log 300, which is 58.
Sure. Here, we got another question.
Okay.
The question is, did you say that COVID vaccine cannot be made a requirement? No, that's not what I'm saying. What I was saying is that some people have been talking about the concept of HIPAA as protecting their right to tell you whether or not they have been vaccinated. And the vaccination question is difficult, and I will allow everyone to interrupt me as I talk about it. But the idea is that as an employer who employs employees at will, you can make it a term and condition of their continued employment to be vaccinated. In that circumstance, you can then ask your employee, are you in fact vaccinated? But you want to make sure, as with any request for medical information, and this is what you want to, that it is business related. If you have an employee who works by themselves at home and never comes into contact with your customers, other employees, you might not have a business justification for a vaccination. If you work in an office building and you sit next to each other like the three of us do on a fairly regular basis, then you probably have a business justification for requiring a vaccination.
And I see that it's 10 o'clock, so we're here to conclude a little bit. And as far as a request to share slides, we are happy to share slides with anyone. Hope you can use them. Hope you get benefit from all the slides. Any other questions from anyone?
There was one more question. It kind of got buried. Let me go back up here real quick. It said, what if an employee provides a doctor's note and records of an absent? Do you need a HIPAA release?
No.
No. Doctor's note and what?
HIPAA is when you're trying to get information from somebody. As an employer, you're trying to get that information from somebody else. So there's a form that you need to have the employee sign to give to authorize a doctor to give you the records. If you as the employer are saying, employee X, you need to justify that you were gone yesterday, all that employee X has to do is provide you with the doctor's note. You don't need a HIPAA release.
Right. If the employee voluntarily gives it to you, HIPAA doesn't apply. HIPAA applies to the medical providers, healthcare providers. That's what the H stands for in HIPAA, are not allowed to provide you healthcare information of a third person, of their patients, without a waiver from the patient. That's really what it does. And so to the extent that you ask somebody for a doctor's note and they get a doctor's note and they give it to you, you're not violating HIPAA.
Okay, well, I think that that was the only other question that I had, and I will share those slides out. We did have a couple people that had to jump off early, and this was amazing information. I know there was a lot of people that sent in. We had 31 registered, and several of them want the recording, which is why we record these. So we will be getting that out as soon as we get it kind of edited down. We'll get that posted. So thank you again for being here, gentlemen. You always do such a great job for us, and you're so giving of your time and information, and we truly appreciate it.
Thanks,
Thank you
Christine.
so
Thank
much.
you.
All right, we will see you guys next month at our next top 5. We'll be rounding out. We've got 2 more left for the end of the year. We do have our Small Business Success Summit on November 5th, and registration is open for that if you would like to join. We are planning in person right now, but of course that is all tentative with conditions changing very quickly. So we will continue to monitor that as well. So thanks for being here today, and we'll see y'all soon.